Adani case will be heard in Supreme Court today, and what we're given to understand, SEBI had filed a petition in front of the Supreme Court yesterday asking for a direction as to where the investigation into the matter of Adani stocks be headed, and that is a very important listing in the Supreme Court today. Supreme Court, of course, is expected to give some direction to the agency.
That's right, Shweta. Specifically on the stock, this news came at about 2 p.m. yesterday on 10th of July, and there wasn't much movement in the Adani Enterprises stock, and I kept tracking it till markets closed at about 3:30. There wasn't any movement, neither is there much movement on the markets today. In fact, let's pull up Adani Enterprises and see where the stock is trading this morning. Incidentally, the stock is up pretty much in line with Sensex and Nifty, up about 0.6% or so. So markets are not reacting to that news of the Supreme Court hearing today. Now remember, this Supreme Court hearing is not specifically on the matters pertaining to Adani's specific role in short selling as a concept and as an allegation by Hindenburg Research. Rather, this is more about SEBI really trying to tell Supreme Court that the expert panel commissioned by Supreme Court to look into the matters pertaining to SEBI's regulatory failure, and that panel coming out with this report in the month of May, that perhaps the rule change of 2019 made it difficult for SEBI to break through the opaque structures of the 13 companies that seem to have allegedly benefited from the short selling at as claimed by Hindenburg Research. Now, SEBI's quarrel with that report is up for hearing in Supreme Court today, where SEBI is pretty much saying that that those 2019 change of rules have not made life more difficult. In fact, life would have been almost as difficult even prior to 2019 in identifying the eventual beneficiaries, the eventual owners, the last faces of those 13 companies that allegedly engaged in short selling at Adani. So the matter is more about SEBI not agreeing with the reporting, with the report of the committee appointed by the Supreme Court, and largely seeking guidance from the Supreme Court on how it should further proceed with its investigations. Now, of course, SEBI is expected to submit its report on the 14th of August, and today's hearing is an interim hearing leading up to perhaps progress thus far on the 14th August deadline. But this hearing has got little to do, from my understanding, with the short selling allegations at Adani Enterprises, and more as not agreeing with the recommendations of the expert committee formed by the Supreme Court to look into regulatory failures, and the specific point that the expert panel had suggested of the rule change of 2019, making it more difficult for SEBI to eventually try and investigate and reach to that last beneficiary, the last owner in the case of those 13 opaque structure companies.
And that in fact was one of the concerns that SEBI had raised. There were recommendations with respect to enforcement policy, judicial discipline, robust settlement, and SEBI, in fact, in its response yesterday, even in the court, has clarified that everything has been taken care of and we are moving with the due judicial process. We will, of course, submit the report on time. So
that's
today's
the
hearing,
affidavit you're
and the
referring
affidavit,
to, not the hearing. The hearing
exactly.
Is
The hearing is expected to be today, but the affidavit that they submitted has made it clear that SEBI is doing what it can. The mandate, of course, is to look into the allegations of short selling. But the petitioner and the affidavit that was filed by the petitioner made something very clear, and I think we reiterated it yesterday on the show. We're going to reiterate it again, and that is there is no clean chit to Adani just as yet. Things will be made clear in the month of August when SEBI finally comes up with its report. But today's hearing essentially will give some sort of guidance to SEBI as to whether it should be investigating the 13 opaque structures that we are talking about.
So I think the mandate is clear that the remit of SEBI is to go ahead and investigate those 13 companies, and that is what this case is all about, Shweta. This case is really about trying to understand that was Adani Enterprises or any other companies related to Adani Enterprises directly funded by Adani Group, not just Adani Enterprises as a company, but Adani Group as a whole, and its leader Gautam Adani, friends and relatives of Gautam Adani. Basically, the case is around trying to understand, did Adani Group or any of its promoters get benefited through short selling, right? And I think the mandate has been fairly clear on SEBI to go ahead and find out who those 13 companies, the foreign investors in the short selling, alleged short selling, are, and who the eventual beneficiaries are. And that remit is fairly clear, and SEBI is mandated to go ahead and investigate and try to arrive at who the eventual owners of those companies are, those 13 companies that allegedly did engage in short selling and wrongfully made gains on their investments on Adani. Now, so I think what SEBI really wants clarity on today is dismissing the recommendation of the expert committee, which said that the rule change of 2019, which was incidentally instigated by SEBI itself, the rule change of 2019 has not made it difficult for SEBI to investigate these 13 companies and the owners of these 13 companies. Rather, try and seek guidance from SEBI on how it should now go ahead and conduct those investigations and those exercises. And my understanding, and this is something that even Mr. Sriram Subramanian, the chairperson of InGovern, yesterday on our show came and said, that perhaps we cannot rule out at this stage SEBI seeking some intervention in terms of intergovernmental departments as well as multinational agencies to come on board and help this investigation go further. So that seems to be the larger context of today's hearing. Now, of course, Vishal Tiwari, Advocate Vishal Tiwari, in his affidavit filed to the Supreme Court yesterday, also pretty much reiterated something that you and I have been saying pretty much, right from the start of the Hindenburg report on Adani, that and the subsequent expert committee report that came out in May, that nowhere in that report has Adani been given a clean chit. And this is something that was widely reported in national media across the board. In fact, even if you do a Google search today, you will discover any finding, any reports filed on the findings of the expert committee and its recommendation doesn't mention, clean chit, but that had been widely reported. So I think it is very simple to say that the expert panel never gave Adani a clean chit. The expert panel never even gave SEBI a clean chit on regulatory failure. And as things stand today, I think SEBI wants to seek further guidance from the Honorable Supreme Court to understand how it should go ahead and investigate the matter further. Right. But of course, we will get some minutes of that hearing today, and then hopefully we should be able to continue our reportage.
And before we move on, Amit, you've worked on a timeline in Adani case. If you could quickly, for the benefit of our viewers, run us through the timeline in the Adani matter.
It's quite an esoteric one over here, but yeah, the simple thing is, before 2019, if you are a foreign portfolio investor, in case of foreign portfolio investors, the beneficiary ownership was mandatory to be revealed only if it was above 25%. And this is the little I understand. Karthik will help me on this. After 2019, it came down to if it crosses the threshold of 10%, it is mandatory. Before 2019, only if SEBI asks you for your ownership details were you mandated to give it, otherwise not, reveal it, otherwise not, if you are under 25% in case of foreign portfolio investors, beneficiary ownership. After 2019, they got it down to 10%. So those were the little opaque structures. With respect to companies, the threshold was brought to 25%, and with respect to trusts, 15%, FPIs, 10%. So that was basically the difference in timelines or the opaque structures that Karthik is talking about. It's a 46-page response that has been filed by by SEBI. So it's quite a tortuous one, to say the least. But yeah, beyond that, I think Karthik has already elaborated on what exactly are the modalities that are in the case.
Right, and there'll be more clarity, of course,
so
later
in the day today. So the question is not as much about who the owners of those FPIs are, but rather who is eventually funding those FPIs, and the profits that the FPIs make, who are those profits being returned to?
Are the Adani companies breaching the public shareholding? So all of that, of course, will be made clear later in the year. As a matter of fact, in August, when SEBI comes out with its report. But SEBI, of course, asking for guidance from Supreme Court in which direction should its investigation investigation be headed thereafter? It's an important session in the court today. We will of course keep bringing you details of that very important session as and when it happens.